Hello, this is Arla Kilpatrick, the erudite Kinophile, and I thought that I would make a video regarding the various laws of the United States pertaining to bestiality. Um, I'm going to be including along with this video a couple of different visual aids to help you better understand the regions that I'm talking about and why it's important that you should figure out where you are and how to get into a more favorable region if you really need to. So, for the first, I'm getting all of this information from the Wikipedia page, Zoophilia and the Law in the United States. Just search for that on Wikipedia and you will get all of the data that I'm using regarding these laws. Now, the first thing I did with these laws is I tried to categorize them in terms of what kinds of laws they were when it came to, so that possibly if a legal defense needed to be put up against somebody in one of these states, it would be easier to categorize what a good strategy for that would be. The first category of law, which in my view is archaic and needs to be removed immediately, is a so-called crime against nature law, or sodomy law. One of them even calls it a buggery law. It doesn't matter what they call it. The point is, this is a law that prohibits zoosexuality specifically because it is abnormal sexually. It is in the same category as homosexual sex, oral sex, anal sex. All three of those, by the way, are now legal due to the decision of Lawrence v. Texas, and as they should be. If consenting adults want to engage in sexual practices with one another, then it shouldn't matter whether those practices can lead to having a baby or not. All that matters is that the two people involved consent, and that they, hopefully, ask one another what their next decision should be. Now, I would argue that animals can do exactly the same thing in their own way, and thus, striking down that law, those sodomy laws, also strikes down a number of laws against bestiality. So in those states where if somebody is being prosecuted for bestiality, I would ask that they get a good lawyer if they can find one, and essentially argue that the law under which they are being held is unconstitutional. It may cause some political backlash and may cause a stricter anti-bestiality law, but if it's successful, if you successfully convince, for example, a state Supreme Court judge that these laws are in fact unconstitutional, then you have given us a really great victory when it comes to the legality of proper zoosexuality. So those are crime against nature laws. The next category is what I would call the rational laws. The laws which are not laws specifically against bestiality, but rather are folded into other laws related to animal cruelty or sexual assault. And really, in most of these cases, I would think that an argument could be made that you don't have to define cruelty as any sexual contact, that you can in fact discern when the animal is being harmed and when it is not, and judge how to prosecute a person accused of this accordingly. Now, this isn't a hard and fast rule. I wouldn't expect, for example, Washington State, which is included in this category, to show that much leniency on these laws for reasons which I'll discuss later. But, in general, if these are the kinds of laws which are being used against a zoophile, then these kinds of laws can be amended without much political pressure, because you're not actually getting rid of the bad part of the good part of the law. The actual sexual assault and animal cruelty laws, great. Let's keep them, but let's amend them so that we don't have to come with this archaic notion of all sexual activity being cruelty or assault. It just isn't true, and hopefully at some point arguments in court will find that to be the case, or possibly arguments towards the state legislatures of these various places. Although a Supreme Court ruling would be the quickest way, if it's possible, to strike laws against bestiality down. Now, there are a number of states where bestiality is specifically targeted by some law or another. Here, the legal ramifications are going to be a bit trickier to figure out, because in these cases, there is no real constitutional argument for prohibiting that these laws be passed, or for prohibiting the enforcement of such laws. You need to actually make some argument that on its own, these laws are unconstitutional without appealing to anti-sodomy laws or the reasons behind the law, as in the case of cruelty or assault laws. I think that this is possible to do, but it's going to be much tougher than in other states, because essentially, these laws are specifically passed because of political pressure to do so. And it's very difficult to get people in power to admit that they've done something wrong when there is so much overwhelming popular support for it in their states. Now, the green states, those are states where zoophilia is technically legal. I mean, it is possible to get prosecuted there in the case of they might claim that you had committed statutory rape with the animal, because pretty clearly it's going to be under 18 when you do anything with it. Or they might prosecute under existing animal cruelty laws, insisting that all sexual activity is cruelty, but there is no specific mention of bestiality in the laws of these states. So if you have a choice of where to practice, I would go with these states. Now, granted, I wouldn't go around flaunting what you do in public, because, let's face it, there are a number of people who would disagree with this and would try to get legislation passed if there was enough public attention brought to it. But, at least in those states, they can't just say, oh, you were having sex with animals, therefore you must go to jail. No, they need to specify why it is under some other law that you need to go to jail. They need to put some twists and turns in their legal strategy in order to get that to work. And, in my opinion, that's all the better for me.